Law did not always live in classrooms with casebooks, cold calls, and finals. For most of human history, law was learned by watching elders, priests, judges, and rulers resolve disputes in public. Early legal knowledge passed through custom, memory, and apprenticeship rather than textbooks. In ancient Mesopotamia, scribes learned legal rules alongside writing and accounting. The Code of Hammurabi shows that law was recorded early, but not yet taught in dedicated schools. In ancient Greece, law was part of rhetoric and philosophy rather than a standalone profession. Students learned how to argue cases by studying logic, ethics, and persuasive speech. Rome changed everything by treating law as a technical discipline. Roman jurists analyzed cases, wrote commentaries, and trained students in systematic legal reasoning. These jurists taught in informal settings that resembled schools, even if they were not called law schools yet. Roman law introduced the idea that legal knowledge could be organized, preserved, and taught across generations. After the fall of the Roman Empire, formal legal education in Europe largely disappeared. Law returned to custom, church authority, and local practice. The revival came in the 11th century in northern Italy. At the University of Bologna, scholars rediscovered Roman legal texts like the Digest of Justinian. Students gathered to study these texts, line by line, with expert teachers. This moment is widely considered the birth of the first true law school. The term school came from the Latin schola, meaning a place of leisure devoted to learning. A law school was literally a place set aside to study law as a discipline. Bologna's success spread across Europe. Universities in Paris, Oxford, and elsewhere developed their own approaches to legal education. Civil law dominated the continent, rooted in Roman texts and scholarly interpretation. England, however, went in a different direction. English law evolved through courts rather than universities. Instead of law schools, England developed the Inns of Court. The Inns of Court functioned as professional guilds for lawyers. Students learned by observing cases, dining with practitioners, and practicing arguments. This apprenticeship model shaped what became known as common law. Even without universities, England still had schools of law in practice. The term law school slowly took hold as legal education became more formal. When English colonists arrived in America, they brought this apprenticeship tradition with them. Early American lawyers trained by reading law under experienced attorneys. There were no formal law schools in the colonies at first. Legal education was personal, local, and deeply practical. That began to change in the late 18th century. In 1779, the College of William and Mary created the first university-based law program in America. This marked a turning point in American legal education. Law was moving from offices to classrooms. During the 19th century, more law schools emerged across the United States. These schools struggled to balance theory and practice. Some focused on lectures and legal principles. Others emphasized courtroom skills and apprenticeships. The biggest shift came with the case method. At Harvard Law School, Christopher Columbus Langdell argued that law was a science. He believed students should study appellate cases to extract legal rules. This method transformed law schools nationwide. The modern image of law school was born. Casebooks replaced lectures as the center of learning. Classrooms became laboratories for legal reasoning. The term law school now meant a rigorous, academic training ground. By the 20th century, law schools were gatekeepers to the profession. Bar associations began requiring formal legal education. Standardized curricula, exams, and accreditation followed. Law schools became institutions that shaped not just lawyers, but legal culture. They taught students how to think like lawyers. They emphasized analysis, precedent, and structured argument. At the same time, critics argued law schools were drifting away from real practice. The gap between classroom learning and day-to-day lawyering became a recurring concern. Technology slowly began to influence legal education and practice. Typewriters, photocopiers, and computers changed how lawyers worked. Yet the core structure of law schools remained largely the same. Even as society moved faster, legal training stayed rooted in tradition. The 21st century accelerated this tension. Lawyers now manage more information, more clients, and more deadlines than ever before. Legal work expanded beyond offices and courtrooms. Emails, digital filings, and remote meetings became normal. The idea of a single physical school or office began to feel limiting. At the same time, the purpose of legal education remained constant. Lawyers must stay prepared, organized, and informed, using tools like Legalizer.